back. You're watching The Firm. For the better part of this year and some part of 2014, foreign investors in India have been crying MAT. Well, now some of them can wipe their tears. Others, they're still at the mercy of the CBDT. The government has accepted the AP Shah Committee report finding that MAT cannot be levied on foreign portfolio investors. But it has decided to ignore the report's conclusion that MAT does not apply on foreign companies that have no place of business in India. Is that fair? Does this selective hearing speak of an obstinate tax department that has almost manufactured a tax controversy where there was none? Well, to answer those questions, I have with me two expert guests with insight into how the tax department works. Former Solicitor General of India and Senior Advocate Mohan Parasran, and joining us as well, former Director General International Taxation and currently Advocate GC Srivastav. Gentlemen, to both of you, thank you very much for joining us. The good news, Mr. Parasran, is that foreign portfolio investors or institutional investors are in the clear, so they have reason to cheer. But the bad news is that the tax department is cherry-picking from the AP Shah Committee report. Yes, I admit that the committee's limited mandate was to offer a view on the levy of MAT on foreign portfolio investors. But that's just a subset of foreign companies. And the committee holds the view that MAT does not apply on foreign companies if they have no place of business in India. Can the tax department, in a sense, ignore the view on the set and only accept the view on the subset?
See, I personally feel I think the tax department has not been quite fair. As I was mentioning to many people, this all started with the decision of the AIR in the Castleton's case, where this point had not even arisen for consideration. The AIR roped in foreign companies on the ground that the definition of a company in the Indian Income Tax Act, Section 2, subsection 17, also includes a foreign company. But on a careful reading of Section 115 JB, it is quite clear that tax on book profits is to be levied only on domestic companies who follow the Indian Companies Act, the rigors of the Indian Companies Act. And this actually virtually came as a boon for the tax department, and immediately based on Castleton, they started issuing notices to various FIIs and foreign companies as well to levy MAT.
Do you think that you can ignore a view on the set and only pick the derivative of that view on the subset, sir?
No, we have to naturally go to the substance of the report of the committee. The reference was quite wide enough, and the committee has also taken into account the liability of foreign companies. Therefore, in my view, I think cherry picking will not work out.
Mr. Srivastav, you worked with the tax department. You often represent them in very, very big cases as well. Can you give us some sense on what grounds the tax department would move ahead on an AAR decision that is binding on nobody except for the parties involved in that particular case, and then now cherry pick from a committee report that very clearly says MAT does not apply on foreign companies that have no place of business in India?
See, the first aspect is whether they could have acted on the decision of the authority for advance ruling. Yes, the ruling applies only to the particular applicant and the department in that case. But once a legal interpretation of a certain provision is given, I mean, department did nothing till Timken's ruling prevailed the field. Then suddenly a taxpayer goes and obtains a ruling, I mean, despite Timken being there, and then the AR disagrees with that Timken view and holds another view. Now the question was that if a legal interpretation of the provision is given, it would have been very difficult for the revenue officers to really ignore that. And I don't blame them for that. Yes, really the answer to that was that a view could have been taken at the policy level immediately following that ruling, whether we really want to levy MAT on foreign companies, FIIs, or other kinds of subsets as you are pointing out. I mean, it's all a matter of why do we leave these things to an ambiguous state of law.
But in fact, Mr. Srivastav, in fact, even though this was not addressed in the policy domain, it was allowed to become a controversy for no reason. Even now that we have an AP Shah Committee report, and it's very clear that a committee cannot assess the applicability of MAT on foreign portfolio investors without looking at the applicability of MAT on foreign companies. You have a clear view from the AP Shah Committee report, and yet we're told that the government is only going to accept the view that applies on foreign portfolio investors, because that was the mandate of the committee, and it's going to ignore the view on foreign companies and allow for that to be litigated in the Supreme Court when the Castleton case is heard. Would you agree with that position of the government or the tax department?
No, even the Shah Committee, if I recall correctly, even they have said that as far as the foreign companies which are having physical presence in India, we do not make any comments.
No, sir. They've not said we do not make any comments. They said we are going to leave it up to. That issue is squarely covered by the decisions of the AR in Timken and Praxair. They've left it up to that because their mandate was restricted, so to speak. But you can't arrive at a decision on MAT on FPI without looking on MAT on foreign companies. Again, I put the same question to you as I put to Mr. Parasaran. This is cherry picking, wouldn't you say?
No, cherry picking not as far as the committee report, cherry picking in the sense that the CBDT instructions which have come, you say that they have picked up here to address the immediate issue, and then they are awaiting the amendments in the Act and the law.
Yes, but the law will only be amended to give relief to foreign portfolio investors.
How do you address the issue by simply asking the revenue officials that please don't take action? I mean, the law has to be laid down to provide for that this will not apply to foreign companies.
Okay.
If that be the
Okay. Mr. Parasaran, the finance minister said in the press conference that he held before accepting the committee report, or at the time of accepting the committee report, he said that the Castleton matter will be now decided in Supreme Court. That seems to imply that the government will continue to take the view it has so far, that is, MAT will apply on foreign companies. How do you expect this to move in the Supreme Court? What do you expect the Supreme Court will look at when it makes up its mind on whether MAT applies on a foreign company like Castleton or not?
See, this appears to be, I think, not a very logical reasoning or thinking on the part of the government or the bureaucrats. When the Finance Act was amended in the year 2015, amendments were specifically made that capital gains arising on transactions in securities, interest, royalty or fees or technical services concerning foreign companies will be exempt, will not be taxed. Therefore, at that point of time, the legislature did not seek to make this fine distinction between a foreign company and an FII or a foreign portfolio investor. Therefore, now they can't actually come out with a new thought that we can still seek to make a distinction between a foreign company and an FII.
Given the fact that this is the position of just one AAR ruling in the Castleton matter, Praxair and Timken were different. Given the fact that for 19 years since MAT has come onto the statute books, there has been no attempt by the tax department to levy it on either foreign companies or foreign portfolio investors till the Castleton decision in 2012, given the fact that so many other countries in the world, and I know this doesn't have legal bearing, but it does have atmospheric bearing, so many other countries in the world do not levy MAT, and if they do levy MAT, definitely do not levy it on foreign companies that have no place of business in that country. How do you think the Supreme Court will view this?
So I will answer only from a very legal perspective.
Sure.
Pre-2015, the Shah Committee's recommendations have taken care of the situation.
But that's only foreign portfolio investors, sir. That's only FPIs or
but that's
FIIs.
what the government says. But that's what the government says. But if you read the entire committee's report, and also what the government has recently been stating the last few days, and post 2015 also, as I said, the amendment was quite clear. The government itself did not seek to make a distinction between a foreign company and a FII. Therefore, in my view, the revenue has a very, very uphill task before the Supreme Court, and the most fairest way to everybody, including the Supreme Court, would be to tell the Supreme Court forthright that the issue has become virtually infructuous, and request the Supreme Court to dispose of the matter in the light of the statement which can be made by the government that they are henceforth not going to tax foreign institutional investors or foreign companies, and MAT will not be applicable to them.
Mr. Srivastava, would you agree with Mr. Parasaran's point of view?
Yes, it could be. It could be. I mean, that position can be taken. I mean, other than those which are having business operations in India, I mean, I think that position can be taken. I mean, it depends on what the government really finally decides.
Can be taken or should be taken, Mr. Srivastava?
Should be taken.
Should be taken. Okay. So given that both of you agree that's what the position, that the tax department ought to take here on, I'm then going to ask you whether this entire controversy regarding MAT on foreign companies that have no place of business in India, especially foreign portfolio investors, is a manufactured controversy. Mr. Srivastava, your closing comments on this debate. Do you think this sort of reeked of tax adventurism, tax terrorism, whatever adjective you want to apply, this was a manufactured controversy?
See, the controversy was not manufactured by the Revenue Department, I must tell you. In fact, for the Castleton also, it was no need to go to AR when already a ruling was holding the field. Anyway, that question should not have been raised in the first place. Now, I won't call it adventurism or terrorism. See, the dilemma of the revenue authorities, we all know that. I mean, if they don't take action on a given set of legal precedents, then also they are called upon to question that why did you not take action. So it was a role that they assumed based on a ruling, I mean, which took some time to get resolved. I mean, unfortunate, but then we can't blame the revenue officials because they are working under a certain under the pressure that if there is a legal view which favors the revenue, that view should be taken, and why was it not taken? They could be open to question. I mean, all that, and I think that was what played in their minds.
Mr. Parasaran, last word to you. I don't like the phrase tax terrorism, so I'll use the phrase tax adventurism. Would you say that's what this episode reeks of?
Yeah, certainly it was a tax adventurism, because actually the AIR did not even have occasion to actually decide this issue. It itself posed this question as a question number 8 in Castleton, and proceeds to actually ignore all past precedents. In fact, AIR was bound by the precedent in Timken, and gives this sort of a ruling, which came in very handy for some persons ingeniously thinking in the income tax department. And all this has resulted in unnecessary controversies, waste of public time, waste of public money, and also public interest, damage to public interest.
And that, Mr. Parasaran, is where the irony of this entire controversy lies, because in the Castleton case, Revenue did not even argue that MAT must apply on Castleton, the foreign company. It is the judge who came to that interpretation independently. Gentlemen, to both of you, thank you very much for joining us this week on The Firm, and thank you very much for watching. We'll see you next week.
The Firm, India's only show on corporate law, tax and audit matters.